Respected Mr. Venkataramani, Senior Advocate, Supreme Court of India, Professor Dr. 𝘊𝘐𝘂 𝘊𝘐𝘂, Professor in Charge, Campus Law Center, Dr. Seema Singh, Faculty Convener, Debate and Discussion Society, Campus Law Center, respected faculty members, students, and all the members of the legal fraternity. I, 𝘊𝘂 𝘕𝘚𝘛𝘐𝘛𝘐𝘛, on behalf of Campus Law Center, extend to you all a very warm welcome to Campus Law Center's Constitution Day keynote address. On the venerable occasion of 72nd Constitution Day of India, we celebrate the charter through which an ancient civilization was set on the road to modernity and social reforms, the framework which enabled the management and accommodation of the most complex ethnic, religious, and linguistic diversity of any modern nation state. The Constitution of India has been the site where different ideas of development have been contested and reimagined. It has been the normative and legal framework through which the world's largest democracy contests its own future. Ladies and gentlemen, today we extend our heartfelt gratitude to the makers of the Constitution and hope to engage the members of the legal fraternity in discourse with respect to the emerging contours of constitutional law. In this endeavor, we are honored to host one of the most eminent constitutional law lawyers and expert in India, Senior Advocate Mr. Venkataramani, speaking on the topic fluidity, the fundamental paradigm of the Constitution. We thank you, sir, on behalf of Campus Law Center for being ever so gracious and accepting our invitation. Now, I would like to request Professor Dr. 𝘊𝘐𝘂 𝘊𝘐𝘂, Professor in Charge, Campus Law Center, to kindly welcome our guest and to address us with her welcome remarks. Over to you, ma'am.
We all know that November 26, 1949 was the momentous day which marked the culmination of assiduous debates by our Constituent Assembly. And on this very auspicious day, I wish you all a very, very good evening. Now, these debates, we all know they led to the birth of a document which reflects the aspirations and dreams of the generations of freedom fighters. This day was observed as the National Law Day since 1979 under the aegis of the Honorable Supreme Court. But in 2015, the Union government decided to celebrate the day as Constitution Day to coincide with the 125th birth anniversary of Baba Sahib Dr. Bhimrao Ambedkar as a tribute to the man very fondly remembered as the chief architect of the Constitution. The Constitution of India, as we all know, has the distinction of being one of the lengthiest in the world. It's an instrument of governance. It's a charter of rights of the citizens. It's a memorandum of duties of the citizens towards the state and vice versa. The Constitution, as we all know, is a living document reflective of the cultural, social, and egalitarian values and the ethos of the nation. The heart and soul of the Constitution lies in the craftsmanship of its framers who adorned it with a flexible backbone to accommodate the ever-changing society without getting shattered. The very fact that we are all gathered here to celebrate the 72nd Constitution Day is not only a living testimony to far-sightedness of the noble vision of our founding fathers, but it is also an unrelenting struggle of citizens to protect these ideals since independence. This day should also serve as a gentle reminder to internalize the values enshrined in the Constitution, for we are not only beneficiaries, but trustees of the dreams for generations to come. We can never forget the words of Baba Sahib, who said, "However good a constitution may be, if those who are implementing it are not good, it will prove to be bad." With these words, I welcome this august gathering consisting of erudite faculty, energetic, vibrant, and ever-enthusiastic students of Campus Law Center, ladies and gentlemen, to listen to our very, very learned and a very renowned senior advocate, Mr. R. Venkataramani, who is the keynote speaker for today. Over to you, sir, to deliver your keynote address on a very, very thought-provoking topic, fluidity, the fundamental paradigm of the Constitution. I, on behalf of Campus Law Center, welcome you to deliver this keynote address. Over to you, sir.
Thanks to the invitation and all my dear students. I am missing the physical presence of the Campus Law Center. I remember way back in the year 1982, when the tall figures of Delhi University law faculty were around there, with many of whom I had occasion to rub shoulders as a willing student to learn from many quarters. And having been a student of Professor Madhav Menon in Pondicherry Law College, the very live memories I have about my visits to the campus law center, and whenever occasion arose, are very refreshing. I wish that we are able to meet in the physical space, but notwithstanding that, sometimes one wonders, when you're talking about celebrating the Constitution as a great advent in the history of the country. Supreme Court has banned the bursting of crackers. Otherwise, they would burst huge amount of crackers and said, welcome the Constitution, right? I remember a story way back in 1935. It's captured very nicely in Professor Day's People's book called People's Constitution. I just read out a couple of passages from that book about a story written by a great writer called Sadat Hasan Mano. And he writes it called a small short story called Naya Kanun, the new constitution. And that was in the context of the Government of India Act 1935. This is how the story goes. The protagonist of the story, Ustad Mango, is a tango driver in Lahore, a classic subaltern figure who is aware and excited about the buzz on the street about the passage of the Government of India Act 1935, which promised to bring greater self-government to Indians. Throughout the story, Mango is elated at the passing of a new act and imagines that it will send the Englishmen scurrying back into their holes. On the day the act is promulgated, Mango is assaulted by an English customer for daring to ask for a high fare. Mango retaliates by landing a blow upon the surprised Englishman and shouting, "Well, Sonny boy, it is our Raj now." Those days are gone, friends, when they ruled the roost. There is a new constitution now. Fellows, a new constitution. Mango is surprised to find himself seized by two policemen who drag him away to the police station. The story closes with the following lines. All along the way, and even inside the station, he kept screaming, "New constitution, new constitution." But nobody paid any attention to him. New constitution, new constitution. What rubbish are you talking about? It's the same old constitution, and he was locked up. And that's a story way back in 1935. But I don't think the story will be rewritten after 1950. Things are far, far different. And Professor Day narrates a story going to make a point, as we will now go about talking on the fluid characteristic of the Constitution. I want to capture your imagination by a couple of observations. One is that if you look at the evolution of the role of courts in the past 300 and odd years, ever since the American Constitution came into being, and the post-1948 Universal Declaration of Human Rights, constitutions springing up all over the world today. So probably hardly any part of the world which does not have some constitution other, except of course England, which continues to have an unwritten constitution. So something dramatically new has happened across the globe, most particularly after 1948. So the emergence of a constitution as an idea, the emergence of a rule of law, so inextricably linked with the Constitution, and all that flows from the marriage of these two principles, number one. And number two, whether the American Constitution, with its emphasis on the rule of law and democracy and the representative character of the Constitution, with its very important, remarkable feature, it not enlisted a set of rights even after the First and the Fourth and the 10th and the 15th Amendment. unlike the Indian constitution or some of the modern constitutions. So questions arise repeatedly, and they continue to arise even in contemporary times before the US Supreme Court and in the political sphere in the US. What about social, economic, political, and cultural rights? How are you going to recognize them through the narrow lens of the US Constitution? Now turn over to a different phenomena happening in the rest of the world. Why I want to talk about these two aspects, and the third proposition is, whatever we imagined and envisioned about a constitution, its features, its characters, and its role in the shaping of a future of a country, whatever we might have envisioned, probably we never thought that the central role that we played in the constitutional drama of all nations is the court. And whatever we understood about the role of court in dispute resolution in pre-constitutional regimes, the role of the court as a central institution in drawing a conversational table for the people, for the government, and for the rest of the community to engage. So it's something which is happening all over the globe today. So I often think when you look at the emerging, expanding role of the courts all over the globe, regardless of the social, cultural, or historical backgrounds of many other countries. You pick up the Korean Constitutional Court or the Taiwanese Constitutional Court, or go to Europe, the Hungarian Constitutional Court. So you can probably, or travel to the South American continent, the Colombian Constitutional Court, pick up any one of them anywhere in any part of the globe. All these constitutional courts are beginning to ask very important questions. And that question is something very different from what probably the constitution makers themselves would not have thought about. When we are talking about a fluidity as a paradigm of the constitution, in the early constitution making days across Europe and elsewhere, and when constitution makers were paying greater attention as the architects, attending to the structure of the constitution, and they looked at whether it's a flexible constitution or a rigid constitution, all that kind of debates went on. So the flexibility or the rigidity was in the context of the idea as to how simpler it ought to be for governance, in order that the constitution does not intrude into various aspects of governance and make it impossible or difficult. Or at the same time ensure that the governance of the day does not trample upon the constitution and make it a useless piece of the document. So between flexibility and rigidity, all the debates went on for a long time. But quietly and silently, unnoticed, came the role of the courts, which is an important aspect of, I say, constitutional law in contemporary world. Now, digressing here for a minute, Professor Lawrence Tribe, and when he wrote his Invisible Constitution, he virtually generated a huge amount of discourse on that. And while the English Constitution takes pride to talk about the unwritten parts of it, and was called the silent spaces occupied by conventions and a variety of such practices in the English constitutional sphere. So when Lawrence Tribe wrote about the Invisible Constitution, you will find a good deal of literature on how and what exactly it can mean to different constitutional frameworks and settings. You will find in a very interesting anthology of writings today, people are comparing with the invisible or the unwritten constitutional dimensions from across USA to a wide range of countries across the globe. I was talking about whether it is Korea or Indonesia in Asia, or Hungary in Europe, some of the, or you can pick up even German Constitutional Court, looking at these ideas in a very important way. So why do we need to talk about the Invisible Constitution, and Professor Lawrence Tribe's talking about it? Now, all of us understand that when it is often said a constitution is a living document, Marbury versus Madison, then McCulloch versus Maryland, all that long line of cases, and Supreme Court of India virtually like in a copybook fashion, saying Constitution is an organic document, is a living document. And what do we mean by all that? And how does it live? And no document lives by itself. No document is an organic feature by itself. So either the document has certain attributes by reason of which people who govern, people who use, people who were able to expand a variety of notions and the rule of law in the light of constitutions, all that all of us trying to do will be to say that if we understand that an invisible part of the Constitution is more important than the visible part of the Constitution, we are talking about something which constitutional lawyers probably a century ago never thought about. So when you talk of, if you remember, one of the old Greek philosopher, Heraclitus, who said, nobody steps into the same river twice because the river is never the same, nor the man is never the same. We're talking about ever-changing, phenomena of the universe. So constitutions also are not tablets on stone. And if they have to be living documents, how do they really become living documents? So when you talk about fluidity, I have a few more observations to make. If a constitution has occupied all the details of governance, if a constitution is able to encapsulate all possible contours of governance and the freedoms that people could enjoy, then I think we are looking at a perfectionism which is not available to human nature or even to human imagination. And we don't have a 𝘍𝘐𝘕𝘋𝘈𝘠 time machine to travel into the future and to fill up all the gaps in a law or to fill up all those crevices in the law in order that we don't have to worry about the future. That does not happen that way. So on the one hand, we have human nature. On the other hand, we have all the complexities of every nation and every civilizations. Compared to probably 100 years ago when colonialism was the uprise, it was doing a different job to different peoples of the world. But with the collapse of, or the extermination of colonialism, and more particularly after the collapse of Soviet Union, we begin to see a whole range of possibilities of governance and methods of governance. We have on the one hand, post the collapse of Soviet Russia, a president who is able to come back to power repeatedly. And then we have a People's Republic of China, which is able to have a hybrid economic and social policies and be able to capture the world market. And the rest of the world, we have also examples of people trying to catch up. I was reading today morning a newspaper published from Kazakhstan, which talks about its 1995 constitution and the importance of constitution to laying down roadways for the future. So we have countries like Kazakhstan in the eastern bloc of Europe. So we find all these things in a way moving towards certain seminal ideas of which we are probably very dimly aware. So what is that we need to talk about? Less informed mortals within governments or politicians who have this rhetoric, they always talk about judicial activism, not necessarily understanding, really comprehending the inevitability of a new role for courts and the need for a new theory about courts. We no longer talk about courts as dispute resolution mechanisms. We no longer talk about courts as mere arbiters between two contesting parties, the adversarial system notwithstanding. Constitutional courts all over the world, whether constitutions are in greater detail or leave it to the imagination or the interpretative exercise of judiciary, constitutional courts all over the world are beginning to assume certain roles which you will probably not find in the Constitution itself. So if you look at our own Constitution, in Articles 32 or 226, I do not know whether the Constitution framers thought that by referring to the kind of writs to be issued by the English courts, we were going to exhaust all the possible scope of jurisdiction by Supreme Court and the High Courts. So way back in the Kerala case, when Supreme Court said in 1961, why do we keep hanging to the past? So the English writs and the narrow rigid frontiers of English administrative law. And when 1979, and in the Roshana case, when Justice Krishna was talking about third world remedial jurisprudence, we have seen a sea change from the departure of the Indian Supreme Court from its attachment to principles of administrative law or the scope of jurisdictions of the courts in English administrative law, etc. So also you will find in the same way, for instance, I just want to throw across a few examples to catch the point. So after Hungary had its new constitution, and in 1989 and before adopted yet another constitution in 2011, Hungary had an old welfare program which conferred certain benefits on women and children. So when the new constitution came and a new government came after the new constitution, there was a legislative measure to withdraw these welfare measures. The matter went to Hungarian Supreme Court. Very importantly, the Hungarian Supreme Court said, we will look at the power of the Constitutional Court not merely as an arbiter, but as a person, as an institution who can discover norms, So discovery of norms. And what did the Hungarian Constitutional Court do? It said if settled expectations are going to be unsettled by a law, I think the law can be more fair if only it has provided for a period of transition. If it has provided for a period of transition and people could readjust themselves to the withdrawal of benefits, the law would have been fair. So not providing for a period of transition is a serious flaw in the law. So therefore, this is the principle of fairness. So this discovery of a principle of fairness, an omission in a legislative exercise, is a discovery of a norm. So you will find many such examples. Going back to the United States, eavesdropping, search and seizure. Many of you are familiar about the case Katz versus the United States. All of us know that search and seizure is illegal if it is adopted by illegal means. But whether eavesdropping was illegal, but whether using technology to listen to a third-party conversation and use it for any purpose whatsoever, would that amount to search and seizure? The US Supreme Court said, yes, we have to expand the meaning of search and seizure, not by reference to age-old understanding of eavesdropping, but if somebody could listen by using any means whatsoever, that will be a search and seizure. Does it not amount to creation of a norm, or expanding or adding layer after layer of meanings to constitutional words and expressions? Is it not an exercise in norm creating? And where do we get the foundation or the basis for all that to be done? You will not find that any constitution whatsoever provides for this kind of a jurisdictional adventures, somebody calls it, or jurisdictional necessities as somebody else may describe it. So we have a wide range of points of view on how different actors assigned different roles under the Constitution are able to usher in new ways of looking at the Constitution or new ways of functioning under the Constitution. I'll give you two more examples in our own country. If you go to our earlier 1950s, who went to the court in 1950s? Somebody called Balsara or Peshika, Balsara, Peshika, etc. All those category of cases in the context of Bombay Prohibition Act. And somebody went to the Supreme Court again in the context of suppression of immoral traffic. These are all ordinary people who are concerned about their own lives and livelihoods or being castigated as criminals. These very ordinary human beings of the Indian continent were able to approach the Supreme Court in the early 50s. But then the story is now unraveling over a period of time. So in 1950s, you will find that the court was not as much eager as to be an agent of norm-creating institution. And why was it so? And one, as a sociologist or a political theorist, or even as a jurisprudential scholar, one can discuss and find out why the Supreme Court of India was not seriously engaged in a norm-creating exercise in the early 50s. And what happens after emergency? And then as emergency made a world of difference, for the Supreme Court to assume new roles, and as it became a new avatar as far as the norm-creating exercise is concerned. So two examples in this context. We have that Association of Democratic Reforms case, which says in the context of Article 19(1)(a) that you have a right to know about the antecedents of a candidate in order that your right, the choice of selecting a candidate is a beneficial one. So where do you find in Article 19(1)(a) right to know? A dimension. So like earlier, both the US Supreme Court and Supreme Court of India have been talking about the dimensions of freedom of speech and expression by saying freedom of the press, or freedom by means of any expression, or whatever be the mediums of expression would be comprehended in speech and expression. Drama, theater, look at any one of them. There's no difficulty about that. They're all well understood shades of meanings of speech and expression. But where is the scope for saying a right to know is part of your speech and expression? The court has to articulate that by knowing well, I do well. So my speech becomes better, my conduct becomes better by knowing well. So knowing well, so as part of again another theory of constitutional interpretation, which has developed in USA, or the penumbral part of rights and shades of meanings. So what I wanted to talk about is, while no constitution today will be generous enough to say that the role of the courts have been seen to be so changing, we need to put it in the Constitution itself. I do not know whether it's going to be a good exercise. There's a large amount of debate on that, but I think it's happening. Whether you want to put it in the constitutional document or not, a changing role of the courts in being the central institutions of giving and assigning meanings to constitutional words and expression is something which probably cannot be reversed now. So whether Montesquieu would look at it in one way or the other, it's a different story. Separation of powers in Montesquieu's style is an entirely different understanding. So all powers being vested in the magistrate is what is worried about. So today, we are not having magistrates with all the powers vested in them as constitutional courts. Limitations may be there, but what we are concerned about is, as constitutional lawyers, and as an important engagement in the future growth of constitutional law, in order that certainty prevails at any point of time. And the way governance institutions are able to predict what they may be able to do and what they ought to do. These are very important aspects of constitutional, and democracy. So all of us, of course, are aware of a wide range of debates in US constitutional law about majoritarianism, then the unelected chamber, then Supreme Court as the least dangerous branch and things like that. But all this, in a way, in a manner of speaking, have quietly gone aside. And that's where I was fascinated by Lawrence Tribe's talking about the invisible constitution. Now, I just give you two examples of two scholars writing about the idea of invisible constitution from the point of view of Indonesia and Korea. And both constitutional courts, in some of their pronouncements recently, talking about the unwritten rules of the Constitution. The unwritten rules of the Constitution, meaning thereby the wealth of norms and meanings and expressions which will be discovered by the court and the court alone. So in one case, the Korean capital city case, the Korean Constitutional Court was talking about the unwritten rule. And the Indonesian Constitutional Court repeatedly talking about rule of law as an unwritten principle of constitution of the Constitutional Court. So rule of law is something which is the bedrock of any principle, and therefore you can wring out any argument from rule of law. So very fascinating, developments across the globe. So that, therefore, it's important for us to look back and take stock about whether the current development in constitutional law happening primarily through courts as conversationalists. Different, academic writers use different expressions. Somebody calls the court as a new conversationalist. Somebody calls court as deliberative institutions. And some others look at courts as the most important norm developers after the 1948 emergence of human rights. So, but all of them are probably talking about or talking about the descriptive element of what is happening. We need to look at the normative element of what is happening. We need to have an understanding, a theory of whether the role being played by the courts is to be subjected to any what called a written principle or a written rule. Then what happens to the flexibility and the fluidity of the role of the courts themselves? That's where I was thinking of fluidity and the flexibility as an important dimension of emerging constitutional, democracy. So the moment you put in a norm in the constitution, it has two problems. Either it has to be interpreted, or it has to, in terms of US constitutional debates, the originalism, the textual interpretation, so on and so forth. You just have to abide by the text of the constitution. You can't go beyond a point and keep on digging meanings and meanings from the text of the constitution. So these two things will necessarily happen. But if you don't put in a norm in the constitution, then is it what called a responsible and more imaginative way of looking at the future? I consider both as problematic situations. So if you don't put in a norm, there is a problem. If you put in a norm, there is a problem. So how do we really, as future constitutional lawyers, we look at this problem? Now, when as a student of constitutional law, when 30, 40 years ago, what were we taught? We were taught about fundamental rights in isolation. We were taught about directive principles in isolation. But post 1975-76, in that 1981 judgment, when the workers, Kamgar Union case, when the workers went to the Supreme Court saying that the property belonging to the factory ought not to be sold and it violates the rights under Article 19 and 21, the Supreme Court said something very important. Because sometimes the court may have jurisdiction, and it may be a jurisdictional point in favor of allocation of its resources, but not necessarily it is justiciable. So the court drew an important distinction between when the court will really engage on resolving a constitutional dilemma or a constitutional dispute. But look at the contrast. Before 𝘊𝘐𝘕, what happened in regard to the exercise of power by constitutional functionaries like the governor or the president? From 1978, the state of Rajasthan case, or even much later, courts were very reluctant to go into or calling upon high constitutional functionaries from offering explanations and justifications of what they're doing. But with 𝘊𝘐𝘕, we find today every constitutional functionary, president or the governor, and have a role to play, namely offering justifications and explanations for what they're doing. Fair enough. So if they offer an explanation or justification, where does the court go? Can the court say, I don't accept your explanation or justification? So what basis, by what criteria can now the court say, well, look here, my rational understanding of fairness is something, and your rational understanding of fairness and acceptable conduct is something else. Therefore, you will find inevitably, whenever it comes to discharge of functions which are an element of discretion and granted to high constitutional functionaries, the element of discretion may vary from time to time. But what is happening after 𝘊𝘐𝘕 is, the court says, no, whatever be the element of discretion, we will no longer call it a political exercise. We will call it an exercise to be subject to the scrutiny of the court. And where do we get that principle? So you will find this kind of norm-laying emergence and the expansion of the role of the court in scrutiny. as students of constitutional law, again going back to US constitutional history, we have all kinds of standards, the strict scrutiny standard or the close examination standard and so on and so forth. So all that are tools which the courts have evolved over a period of time in order to justify what it proposes to do. But none of these exercises, I would say, none of these attempts can be traced to any principle in the Constitution itself as a jurisdictional principle. So where is the problem? Is there a dilemma? So all that is a very fascinating journey into the past and of course into the future. I only want to draw your attention today to this wide, ranging developments across the globe to capture 2 or 3 important aspects. I personally think that, as I was saying earlier, that there is a need for a new theory of courts, and there is a need for understanding the limitations of fairness in governance and accountability in governance, and particularly because today we cannot call upon any government in any part of the world to have any doctrinal principles of economic theory or political compact to guide them. So, given the developments within capitalism and given the near collapse of certain parts of the Marxist doctrines of dialectical materialism and so on and so forth. So no country in the world today have any textbook principles on economics or political compact to be able to deliver good governance. If that is so, what are the standards under which you will say a right to health or a right to food or a right to clean environment? So if a couple of weeks ago, the Supreme Court of India was talking about what's happening in the city of Delhi. Now, whatever that may happen, you may ask questions. But the important question is, where do we get answers? And how do we get answers? And who will provide a final answer? So these are very important questions to be asked. I don't propose to talk from a very conservative point of view on this separation of powers. I don't think that Montesquieu is any longer relevant as the way he formulated propositions. But there is some important element of called distribution of powers in a constitutional framework. And how do you really distribute them? There can't be any rigid principle there. So lines will be moved from time to time. Demarcations will happen from time to time. But when you say from time to time, when all this fluidity happens, what should be the final demarcation? Or what should be the final framework? Can we talk about it? Or it's in the very essence of democracy and rule of law that none of these things should be brought within any rigid framework or norms criteria. It will be left to the emerging times, the genius of the people, the principles of accountability, internalized by governing institutions. And if only possible, we can talk about changing some structures of the governance institutions in order that accountability is much more. We can probably talk about changing the structure of the judicial institutions to make it more closer to the needs of the people. But that would still not close the kind of issues I'm trying to talk about. They'll always remain there. And as long as they remain there, I think it's important that they remain there. And because I think we are talking about an open society, we're talking about the unseen dimensions, the rule of law, the non-violent revolution. So there are so many things which need to be seen probably in the next decade or so, when across the globe, when new compacts, political, social, economic, will emerge. We have seen that during lockdown and thereafter, lots of new developments are taking place in China, in Europe, in USA, and we'll probably see these developments impacting migration of people, migration of capital, and movement of resources across the globe, and the new ideas on economic regulation, so on and so forth. So while we are, on the one hand, we are fascinated to read the contributions by people, like Piketty writing on the new dimensions of evolving capitalism and its failures. And we also read about what's happening in countries like UK or even some countries like Germany, for example. So the collapse of certain institutions across the globe is another development to be noticed. And why are they collapsing? Because we are still trying to have a round and a square peg aspect. So what seemed to be institutional good governance structures maybe a century ago, whether the Westminster model or the federal model in USA or certain models in Switzerland, Germany, or accountabilities are now no longer the same. So we need to look at governmental structures and their changes. We need to look at judicial institutions and their changes. And therefore, we need to look at a larger connection between all of them taking place. My question is, can Constitution provide for all of this? Can any Constitution provide for all of this and provide answers within the Constitution? I think my own answer will be no. The Constitution will have to be an attempt, an endeavor, and a modest attempt and an endeavor to look at all of them and to provide platforms and foundations and to be able to throw some glimpses into the architecture for the future. And that's where I think we will be able to capture the fluidity or the flexibility of the future constitutions. The flexibility and the fluidity of future constitution are far more different from the inflexibility or the rigidity of the constitutional debates of the past. They're entirely different, both in theory and practice. So I would probably invite more questions, then so that make it a little more interactive and maybe more exciting than what I'm trying a monologue across, right? So I would like to close now and probably invite some questions. And
yes, sir. That was a stirring keynote, sir. Your persona and your mastery in constitutional law is continue to be unparalleled. Thank you so much for taking time. I am Vijay Pujari, sir, and if you permit me, I'll go ahead with the Q&A session, sir.
Yeah.
Yes, sir. So my first question is pertinent to this very holy book, Constitution of India. Do you consider Constitution of India to be a book of rules or a book of doctrines or a combination of both?
Can there be any constitution which is merely a book of rules?
Perhaps not.
Look at our preamble. Is it merely a book of rules? It is full of doctrines, right?
Yes.
Now look at Articles 15 and 16. It's full of doctrines. Yes. Article 17, Article 18, right? Look at Articles 25 and 26, doctrine. No constitution can say that it is not a doctrinal document, because our political understandings are full of doctrines and theories. We only have captured them. We call them norms.
Yes.
So the norms are only the clothing with doctrines are born. But they become rules because for the governors it become rules.
Okay.
That's where I think if I belong to one particular political party, I can read freedom of speech and expression in one way. If I belong to a different ideology, I'll read it in a different way. So I just want to make one observation here in this context that there is also an increasing debate in USA saying that the US Constitution has laid a lot of emphasis on rights, whatever be the narrow conceptions of rights provided in the First or the 10th Amendment. And there's a need for talking about responsibilities and duties. Very recently, I think the Prime Minister said something about duties and then the rights. So I read an article in an online magazine saying that the Prime Minister is wrong in saying that the Constitution has space for duties. So we have very interesting debates like that, right? So doctrines, I think, will necessarily inform law and constitutions. Look at the expression in the contract law, good faith, right? Good faith is an age-old principle of being decent to each other.
Yes. So my next question is again pertinent to this very thing. So we are a robust 1.4 billion sample size, and this happens to be, at least it's told, that it's a functional democracy. And as far as Supreme Court being considered as the interpreter-in-chief of the Constitution, how far can we give the tag of caretaker of the Constitution to the Supreme Court? And how, I mean, as it's seen today, that legislature pushes the boundaries a little further, while Supreme Court is the one to bind the legislature to its normative positioning, as it's seen.
As I said, this contest is inevitable. Who wins in the contest is a matter, again, of a rational debate. So suppose in the context of a right to food, or take the recent debate about the farm laws. So we will say that certain aspects of progressive legislation, which the government says is progressive, are unconstitutional. So we are no longer back in 1950s when the first amendment to the Constitution was brought in because the Supreme Court invalidated certain zamindari, legislations. We're no longer in that framework. Our understanding of right to equality, our understanding of the role which economic governance and regulation will play in enhancing the quality of lives of people. So there, legislature may claim the last word. And because the legislature may say, well, you have the right to test on certain norms, but you can't assume to yourself to be the policy maker and sit in our position. So these kind of debates will inform. I think they must inform, and they must continue to inform the exchange of views between the legislature and the court. The borderline is very difficult to draw.
Okay, sir. Yes, sir. So my next question is with regards to constitutional morality as a concept that is recently developed. The word constitutional morality does not see any mentioning in the Constitution, but although Ambedkar does mention it a couple of times during the debates. So while you were talking about unmentioned part of the Constitution or unwritten Constitution itself, so whenever the Constitution is silent, do we fall back on the constitutional morality to resolve the matter for us?
You will find very often when the courts have to articulate the foundations and the basis for his opinions, depending upon a controversy in question, the court gives a wide range of explanation, reasons, and try to connect them together. Sometimes there can be hypotheses, sometimes there can be doctrines, theories from political science or social sciences, or even it could be from pure sciences, right? We have several such instances in the context of abortion in debate in USA. So the courts will have to necessarily give a wide range of explanations and justifications. But when it can legitimately do so, when the court says, I am going to wear one more armor, and for what reason? Suppose I understand in political dialogue, we talk of constitutional discipline, constitutionalism, right? Constitutionalism means nothing but constitutional discipline. That power must be exercised in accordance with the Constitution. Accountability of governance must be in terms of the Constitution. So we talk about constitutionalism, already it is there, right? Now, when you talk of morality, it's something so innate as why, regardless of the fact that all of us are taught from morning to evening by our parents, by our teachers, whether in schools or whatever, wherever it is, the don'ts and do's and things like that. And that's because we have some innate urge and the need to do something and not to do something. Sometimes we can discover it by ourselves. We can see the pain and pleasure of somebody, a third party, which is caused by us. So we immediately respond to the pain and the pleasure. We share in the pleasure and we partake in the pain, right? So we try to, something in part of human nature. That's what morality is about. So when you bring an idea, which is part of human nature, into a what called an architecture of social governance of a country. Sometimes it seems to be superfluous, or what called an exercise in extending a principle which may break down. So you don't have to go all that, let's say, constitutional morality. You can use all kinds of other expressions within the Constitution. But what has happened is, take the case of Sabarimala, where it has come to the forefront, right? So the court has to go extra mile to say what I've done is right. And why I say? Because look at the morality of the Constitution. I don't know whether that is going to be really a new principle for constitutional adjudication. Can it not be a slippery principle? So invoking a huge amount of subjectivity in somewhere, I think, in one of the judgments where the court went into privacy, we're talking about privacy, the court's talking about the right to food, the kind of a choice of food as privacy. So the right to sleep is a fundamental right. So what is that? Therefore, these could be some kind of fringe aberrations, if you put it like that.
Right, sir. Allow me to push it a little further here, sir, because we're talking about morality. How does the Constitution Court interpret the word morality, and what exactly does it mean per se? Because I want you to emphasize here whether the constitutional morality that Supreme Court speaks of today, is it the morality of the 299 odd people present in the Constituent Assembly? Is it the morality of the 500 odd pages of this book? Or is it the morality of the 1.4 billion people? Or is it the morality of the majority of this elected democracy?
Whenever you see a text, you pick up a piece of poetry, right?
Yes.
You enjoy it because you understand it. Yes. But some poetry is not enjoyable because you need a commentary on that. You need a commentary on it. Somebody would write about what Shakespeare meant. Literary criticism, is a huge exercise, is an industry by itself. So when you need a commentary on what a word or somebody meant, that means inevitably there's a room for somebody to say what it means, what I understand it to mean, what all of us must understand it to mean. All that seems to be happening. There can be never any agreement on that. So what it means is an easy exercise. I pick up dictionaries, and if dictionaries are not helpful, we try to find out from other sources. And why do I hunt for it? Because I think as an individual mind, I need to reach at some meaning, which I think is the correct meaning. All the time, judges keep doing that as constitutional interpreters. They do that. Therefore, the ultimate thing is, what is the meaning I want to be implied? So I think that's the meaning I want to be discovered, and that's the meaning I take the meaning to be accepted. So that's why this constitutional morality issue seem to be getting into all kinds of debates.
So my last question here would be again with referring to elevation of Judge Kavanaugh to the US Supreme Court. Do you see, at least in foreseeable future, revisit to NJAC happening? And is it the right way to go about? Does legislature have any say in appointment of judges? Or Supreme Court an impregnable fortress, as they say?
So an appointment process is seen as a simple process. When somebody unhindered is able to take a decision, then it has a simplicity about it. But since we found the simplicity assumed by the collegium has become complex, so we have a new thinking on that. So the executive has a simplicity of choosing judges, any part of the world today, right? And that task of choosing judges will necessarily involve a wide range of factors. We as a citizen, I think, should be concerned when somebody who is not equipped, not intelligent, right? Or who is so visibly, oriented towards certain extreme propositions, then we ought to be careful about it, because we have a right to be governed properly, not only through legislature, but also through judges. So today, I think the more you introduce more and more people and players and actors in the selection process, the simplicity is lost. So the idea is, how to protect or to generate a simplicity in the selection process, but at the same time ensuring that the procedures and the processes generate, accountability and acceptability. Many of us, or I do not know how many of you are aware of what's happening in UK. So if you have to be in the run for appointment as a judge to Court of Appeals or to further higher institutions, so you were asked several sets of questions, which are deeply subjective, and the questions asked in a questionnaire may go up to this: have you ever cried in your life on seeing a misery of somebody else? It's a lot of interesting questions being asked there. So we need to test the equipment or the caliber or the fiber of judges before they become judges. Do we have a procedure for that? Can there be an infallible procedure? I don't think so. There can be some procedure, a good procedure.
Thank you so much, sir. It has been an absolute privilege moderating this session, sir. Thank you so much for taking time. Now I request Dr. Gunjan Gupta, Professor of Campus Law Center, to deliver a vote of thanks.
Good evening, everybody. Respected Shri R. Venkataramani, Senior Advocate, Supreme Court, Professor Alka Chawla, the Professor in Charge, Campus Law Center, my colleagues and dear students. It's my privilege to have been asked to propose a vote of thanks on this occasion. I, on behalf of Campus Law Center and the entire team of Debate and Discussion Society, and on my behalf, extend a very hearty vote of thanks to Shri Venkataramani for gracing this occasion and having shared with us his findings and opinion this evening. And I've been noting certain key points which Sir had been highlighting, that is the need of theory of courts, that identifying the changing role of the courts, the need of accountability and governance, and even highlighting the important element of distribution of power. A big thank you to you, sir, for your efforts towards sharing your views on this celebration of Constitution Day on the topic fluidity, the fundamental paradigm of the Constitution. I may like to express a sincere thanks to you for giving an excellent coverage and I express my gratitude for providing the encouragement to our students. We are all inspired by your great words. I would fail in my duty if I fail to appreciate the efforts made by the Debate and the Discussion Society and its technical team in making this program a great success. Thank you so much, sir.